Jersey is even smaller than Singapore, but we do have a full statute book. This talk is not going to be technical like many of the other talks. It's more of an invitation to people to consider seriously researching statute law as data, to take data approaches to statute law. Just to start with, I particularly noticed in Professor Ashley's talk at the beginning of this conference, where Jason Morris asked him about extracting legal rules from statutes, and he said there wasn't much of it, and they generally haven't succeeded in automatically extracting rules from statutes. And it does make me wonder why there hasn't been more attention to statutes. There's been a lot of attention to cases. I've got this quote at the bottom here from Tennyson, the codeless myriad of precedent I really like in these days, written in 1793, but he was obviously looking forwards. Statute books, I don't necessarily mean the books on a shelf. By statute book, I mean the entire set of legislation of a jurisdiction. So are they data swamps? Are they data lakes? Are they data lake reservoirs? Could they one day be data reservoirs? So I'm going to look at the paper looks in particular at the prospects and dead ends of taking this approach to data, and particularly at what offices like mine. So each person at this conference will have somebody who drafts the legislation for their country. So rather than looking at case law and contracts, I'm looking at statutes. My particular background is a Commonwealth background where we have professional drafting offices. Obviously, America is different in that everyone drafts in America. Members of Congress draft for themselves. And obviously, European civil law countries are different again. So if you're going to take a data approach to legislation, then in the same way as with anything else, you've got a set of choices facing you. First of all, what scope do you want to place on the data that you're going to look at? Primary or secondary legislation, regulatory guidance and codes produced by independent regulators. But then there's the question whether you're looking at one country, your own, or several, or globally. And then there's whether you're looking at the entire statute book or you're just looking at a particular topic. So it's common to look at business or financial services or something like that. Obviously, as with everything else, the quality of the data matters. So are you applying natural language processing to raw text? How much data cleansing are you having to do in order to make that work? Or does the jurisdiction that you're looking at already structure its legislation? And I would say the good thing about legislation is it's by its nature structured compared to things like case law and contracts. Within one jurisdiction, there should be a fairly consistent approach. Then there's the question of what questions you're looking to answer with a data approach. You might just be looking to see what happens when you apply data methods. But the sorts of questions include, is there too much burden on businesses or citizens? Is there too much of the statute book that's outdated or overlaps? Are there patterns, which is one of the things I will come back to in particular, so that for various reasons you might want to find patterns, either across different countries or to help standardize what people draft. And then another question would be, there's a lot of theory about these days about how legislation fits together, but does the actual legislation on the data book, does the actual legislation on the statute book fit that model? And then finally, my key interest is in rules as code, which is if you like, embedding coding or markup into new legislation to mean that computers can extract some of the logical structure and the some of the normative structure from it. So I particularly in the paper mentioned two recent projects that I think are of interest. One is by the United Kingdom government's Department of called BEIS, the Business Department. They're calling it the Open Regulation Platform, and they're looking at legislation, primary and secondary, but also regulatory material from codes of guidance, that kind of thing from regulators. They're only looking at the UK, and they're looking not at the whole statute book, but at what's relevant to business. The other one that's particularly worth mentioning is the Regulatory Genome Project that's being run by Cambridge University. I'm not quite sure, I've been in touch with them, but I think they're only looking at legislation rather than guidance. Their ambition is to look at the entire planet's legislation, which is a fine ambition. And they're looking at financial services rather than any other kind of legislation. So that's two different projects with different permutations on the scope questions that I mentioned earlier. If you are looking at legislation, then one of the first questions in deciding the scope of what you're going to pour into your data lake is which versions. So most jurisdictions now have multiple versions of legislation. In the old days, you just had what was enacted. A lot of what's enacted is amending other legislation that already exists. So in a sense, it might not be that surprising if you found that the commonest word on the As-Enacted statute book was the word substituted, because that's what most of legislation is doing. It's substituting something that's already in something else. The other key point about legislation that many people from a technical background don't immediately grasp is that it goes back a long way, and that it means that you now have a patchwork. If you're looking at current law, you're looking at a patchwork that's been put together. In the UK's case, their first statute is 1267, and it's in Latin. And in fact, I've got a screenshot there of the legislation.gov.uk site, but they show the traditional English translation of this particular statute, and then they have a JPEG of a photo of the Latin. Because it's in Latin, it's not just ordinary Latin, it's medieval Latin, it's in shorthand Latin with all sorts of little superscripts and subscripts that would be impossible for any NLP program to make any sense of at all. Then, depending on the jurisdiction, you'll have consolidated versions. So not all countries do consolidate. By that, I mean bringing together in the amended piece of legislation, you bring in all the amendments up to date to that piece of legislation. So the United States has the US codes. It depends how frequently legislation is consolidated. It depends whether it's official or unofficial. And it depends also how far back that consolidation goes. If you are looking at a consolidated text set, then a key point is that you're missing out everything that's been repealed. Just to give an example of that, so Jersey, where I work, we have a website that's not directly under our control. It's shared with the courts for court judgments, but we have the as-enacted text of everything. And then we have current consolidations. They effectively go back to 2004, but the entire statute book that is current at the moment has been consolidated, and every amendment is put into that current consolidated collection within a day of being made. That is done manually, not using XML that some other jurisdictions use. We also have some archive. We're still working on the way that the older versions work. We have some where our Parliament, the Assembly, has passed a piece of primary legislation, but it's gone for royal assent, which in our case takes a few months. But what we don't do is try to mark up where something has been amended, but the amendment hasn't been brought into force. Some jurisdictions do that. So earlier I was talking about you can look at legislation, you can also look at other documents, you can look at regulatory material, but you can also look at background documents. And so here's some examples from Jersey. What people in other jurisdictions might call a bill, a proposition in Jersey terms, is the draft that's produced by a drafting office like us, put to the Parliament for the Parliament to debate. We have them on a separate website for our Parliament, but unfortunately on that site, they're only there as PDFs. And they're generally in there with all the other non-legislative propositions. But on our legislation website, we link back to those propositions so that you can trace the legislative history through that. We also have secondary legislation made by ministers called orders. When they're made, they're on the legislation website, but they come with expansion notes written by us. But to find them, you have to go to a different part of the Assembly website. And they also come with the reasons why they were made. But to find them, you have to go to yet another website, the government's website, where ministerial decisions are recorded. So I've mentioned XML already. One of the key questions, if you're taking a data approach to legislation, is what is the state of that legislation? Is it just raw text? Are you going to be using our NLP on it? Or is there some element of structuring? So, like I say, our bills are static PDFs. And the UK's original legislation is just an image of a Latin text. But it can be part structured. We don't use XML, at least not yet in Jersey, but we have Word and HTML, and it's done in a structured fashion. Then you have XML schemes that have been around for quite some time that are specific to different countries. Some people looking at JSON. The interesting thing that's coming up is a Coma and Toso, which is an XML designed for parliamentary and legislative and judiciary documents. So it could combine them all, but it's gaining a lot of ground. So legislative XML, I've just given a few screenshots there from the US, Europe, the EU, the UK and New Zealand, just as examples. There's plenty in Australia as well. But in particular, a Coma and Toso is gaining ground. So the UK is using it. There is an application of it to the United Nations. The EU are looking at it. And even the United States legislative markup system is derivative of the Coma and Toso. The possibly the most important question is, what question are you trying to answer when you're analysing a legislative data set? An interesting case to look at is a report by the New South Wales Treasury called Regulating for New South Wales's Future. And they used a proprietary program from Deloitte. I had a lot of concerns about the report when I saw it, and we'll see some of those issues as we go through now. So they claim to be looking for outdated references, in particular references to outdated technology. So, and this may not be necessarily fair on the original work. I'm looking at the way it was reported in the report that was drawn up by the Treasury for it. So they were very keen to point out that there were 350 references to facsimile in New South Wales legislation. I'm not at all sure that they really had got to the bottom of whether that was significant. When I had a look at the New South Wales statute book online, from what I could see, whenever it mentioned facsimile, it said facsimile or other transmission of the information. So it would cover all electronic forms of communication. The fact that an older technology is referred to doesn't necessarily mean that you're obliged to use the older form of technology. It just means that that was mentioned at the point when that was current, and then we've added something since to future-proof or to cover other more modern electronic means of communication. So to claim that that means that legislation is outdated seems to me very misleading. The other thing that they looked at was duplication overlap, but they seem to think that cross-references were a bad thing. There are different styles and different approaches in different jurisdictions about cross-references. Many of the Australian jurisdictions don't like cross-references because they think it makes it harder for the human reader. Many other jurisdictions are perfectly happy with having lots of cross-references. But the report talked about interpretation acts, but still seemed to reckon that that made it more difficult for people to follow the legislation. But they didn't really say in what way. And they also talked about standard provisions, which actually positively avoid overlap. So the cross-reference to standard provisions is definitely not a duplication or an overlap problem. They also tried looking at whether things were out of date just in terms of their age. So they looked at when it was first passed and how many times it had been edited in their terms, amended in our terms. They do admit that that's not a proxy for irrelevance, but they do say that it's an opportunity for review, which might be true. But the fact is that constant new legislation, constant new amendment is a burden on business that business complains about all the time. So saying that because it's old and hasn't been amended that often, it must be burdensome, seems to me back to front. The most worrying thing, I think, is when people think that you can weigh regulatory burdens by looking for what they call prescriptive language. And they seem to, the impression that is given in the report is that they counted up numbers of times shall, must not occurred. They also mention cannot and ought, which you won't find in legislation except in non-prescriptive senses. And the main problem there is that in modern Commonwealth legislative drafting, we don't use shall anymore, but we used to use it and we used to grossly overuse it. So we would say shall mean. So in a definition, instead of saying dog means animal with 4 legs, in the past, we would often say dog shall mean animal with 4 legs. There is clearly no prescriptive or regulatory burden element to that. It's just pomposity, I'm afraid, in dressing up a definition with the word shall to make it sound more resonant. So that, in that sense, trying to use shall as a guide, or trying to use any particular word as a guide to find obligations, is going to be difficult, and is something that definitely is worth talking to your local legislative drafting office about if you are looking for that kind of thing, to see how their statute book works. The other thing that you can do is look for patterns. a lot of the work that's been done on finding patterns and using graphs has been about case law. Obviously, statute is different. We don't need to cite other statutes to give authority for what we're saying. It's been used most successfully, I think, in the civil jurisdictions where people have looked at the codes. And there's been some work looking at different types of cross-reference and whether you're cross-referencing to a different statute or in the same one. And there's also this question of implicit or explicit. The point about an Interpretation Act is that you shouldn't have to quote it. The point about an Interpretation Act is it applies unless you say it doesn't apply. So people do need to look at Interpretation Acts. The other thing that in most of Commonwealth countries and many other countries, there's a principle that if you use the same word twice, even though you don't define it, you must be taken to have meant the same thing by it, whatever that might be, on each occasion. So in that sense, some data approach that looks at what words are used would be very helpful. The uses of looking for patterns could include finding similar patterns in other countries. So the Regulatory Genome Project has looked at that across different jurisdictions. In the UK, this Common Legislative Solutions approach has been trying to produce standard questions for policy officers and point them to typical drafts. And pattern detection could be very useful there for drafting. I mentioned rules as code earlier. The idea that I'm particularly interested in is when drafting new legislation that we manually add markup for the logical structure and the normative content, the musts, the must-nots, and the mays. But it would be very interesting to me if a data approach to existing law could start looking for the set of things. Sorry, excuse me. So picking out the if-then structures, the lists without an or, the musts, must-not, and mays, who those are imposed on, what actions they're about, picking out the definitions, and picking out some of the account sales rules. That's a longer term ambition. In the shorter term, Jason Morris, who spoke earlier at this conference, has also talked about how he's tried to analyse a particular Canadian act, looking to see what sorts of expressions come up most often. And his purpose in doing that was to work out what the best kind of language, computer language, would be to implement that legislation in code. The other one I mentioned earlier is just that there is this theory going back to Coode, the original code, he's pronounced, the original legislative drafter, that we have a legal subject, a copula, and a legal action. But it would be useful to see to what degree that is a real reflection of the statute book. So that's a very quick skim. There is the paper if you want to read any deeper. I do hope that it does encourage researchers to look at statute law more than perhaps people have so far. And I would encourage anyone to get in touch with me if they're interested in doing that. But if you are looking at doing any analysis of a statute book, my particular plea would be to get in touch with the local version of me or local legislative drafting office. And the Commonwealth Association of Legislative Council is a good start for that. And then you can find out from them whether they consolidate, how often, how far back, whether they're still using shall if they're an English language one, and whether they would share their unpublished files and what format those are in, obviously. So then the question would be whether this current swamp of statutory data might end up becoming a reservoir. So on that, I will finish and see if there are any questions. Thank you. I've got a question in the chat from Rochelle Furneaux. Rules as code, are you thinking every act will be turned into code or only particular types of legislation, such as entitlements type legislation? My idea of rules as code is that it ought to apply to all kinds of legislation. It's just that you're not trying to computerize and automate the entire piece of legislation. You are trying to look at all the if-then structures, which all legislation uses, and you are trying to pick out where there are definitions, where there are obligations, but you're not trying to write something that necessarily means that you can automate execution of that. The general vision of rules of code is a broader thing about how to capture legislation in code. But the original version, which is popular in drafting offices, is that governments would publish some sort of markup which other people then would take away and use to produce whatever sorts of programs they wanted. So in that sense, it fits more with a data approach. Hope that answers that one. Thank you. Would there be any other questions? Well, in that case, if there isn't anything else, shall I hand over? I think we're a couple of minutes before I was due to finish.
Hi, Matthew. Can you get us?
Yep.
Yeah, sorry. Okay. We got muted for some reason, but we have a question for you.
Yeah, I'll come again. I hope I have the same text as the first time I asked that question. This is Dirk from the Zurich Law School in Hamburg, and I would absolutely second all that you've said. Considering that in our research group we would think we are legislation scholars, and from what you said, I understand that the data that you have available, which is what we would be looking for, the legislative data, is something that could be used for scientific research. So if we bring a framework fairly comprehensively of analyzing over time, analyzing snapshots, networks, all of that, if we reach out, I think it might make an interesting collaboration, wouldn't it?
Right. I mean, one way or another, legislation is law the same as case law is law, but a lot of the data approaches seem to have focused on case law. I don't see any reason why not to use legislation. I don't know if it's that legislation looks too easy. It's not, but legislation is more structured than a case report. Whether that means if you're particularly keen on NLP, that you're not going to get as much benefit out of NLP as you do when you analyze whole screens of case reports. But yeah, one way and another, each legislative drafting office publishes its own legislation and has that material available. Obviously, on what terms it can make it available to researchers, it's different between each office. But I suspect that most offices would welcome an approach.
And I think, any other questions?
Would it be possible to obtain your email for further, maybe to reach out? This is Geddes, by the way, to reach out personally. Somehow we can't find your email on the internet. Thank you.
Right. My official email is easy. It's matthew.waddington. So my name with a dot between it at gov.je, JE for Jersey. And it really is that simple. People don't believe me when I say that, but it really is. That is my email address.
Okay, thank you.